registration. And just a little bit of background that what we want to do tonight is we want to hear from you and let the council get feedback from the public. So that's the meeting. We're not going to do a lot of talking. We'll just go over the ordinance, but just a little background. So back on February 13th, the council had a work session, and this was one of the topics one of several topics that came out of that work session. So then from then it was the March 13th Committee of the Whole that directed the staff to put together a proposed ordinance that was mailed out to the 401 property owners on June 6th, not managers, but it was mailed to the property owners. And then that letter, I'm assuming you all, most of you received it, requested the feedback, and so here we are tonight for the public meeting. So Lynn has up on the screen the number of registrations and the different types. And so I haven't seen this sheet before, but it looks like into the best practices, there's 1,166 units and 343 buildings. Standard practices, there's 271 buildings, which includes 753 units. There's 53 buildings and 245 units that are exempt, and the total number of rentals in the city is 667 buildings with 2,164 units. So, again, tonight, the intent is for the council to listen. I don't think we need to engage. Tonight, we want to listen. Any questions directed at staff, we're going to take the time to get the answers, and the council will come back on August 5th, and that's when the council discussion will take place, where the council will decide if this is an ordinance that they want to move forward, or if it's an ordinance that they don't want to move forward. So I think the first thing I'd like to have happen this evening is have Rolf, the city attorney, just go over what the current ordinance and what changes are in this proposed ordinance, so we all have a basis of what these changes are. And then I think we're going to talk about those changes, but then, again, we just want to open it up to you. So of course, we're going to be civil, we're going to be respectful tonight, that's not a question. Everyone is going to have the opportunity to speak. The only thing I'd ask is if you're making some of the same points, that's fine. You get the opportunity, but let's just keep those comments relatively short if there's a lot of people that have the same comments. But we want to give everyone the chance to speak. So, Rolf, do you want to take it from here and just go over the
Thank you. Can everyone hear me? Is this better if I talk a little closer? Okay. If you look up on the screen, it's going to identify kind of some of the comparisons between the current ordinance and the proposed ordinance. And for those that participate in best practices, I think you're going to see that there isn't going to be a whole lot of change. Those that don't, there may be, because of the fact that one of the things that the council directed was that they wanted the units inspected. And so with that backdrop, if you look at the current, which is the left side, versus the proposed, for currently right now, we do registrations that are issued by the city administrator's office. The proposed ordinance will actually have a license that's actually issued by the city council. Envision that the same or similar application would be provided, but it would come before the council on a license basis. The city council is the entity that issues licenses. Regarding inspections, the current practice is that inspections are mandatory if you're part of the best practices, and I believe you're inspected once every 3 years. It's not mandatory if you pay the full registration fee. Under the proposed ordinance, inspections, all rental units or all rental dwellings must be inspected at least once every 3 years, and the fee includes the inspection, and includes also a reinspection fee if there's any noted deficiencies that need addressing. Inspection standards are the same. Compliance with state building codes, fire codes, property maintenance codes, city, state, and federal laws, nothing changes there. These are building codes that have been adopted by the city and are basically standard more or less throughout the state of Minnesota. Relating to exemptions to a license or registration, not much changes there, except we provide a more comprehensive list to make it more clear that owner-occupied units, where the owner actually lives and shares common space with the renters, that those would be not required to license. They weren't necessarily required under the old license, but they're not necessarily required because they live there. Inspection violations, the current practice is that a compliance order is issued requiring immediate repairs and a reinspection for compliance. The proposed ordinance for compliance or inspection violations, there would be a compliance order issued, including a correction order, which would make it clear exactly what needed to be done, and then a reasonable amount of time would be given for reinspection and compliance. So what it does is it just simply makes it a little bit more clear, a little bit more reasonable to allow for compliance to occur, as opposed to making it happen sooner as opposed to later, depending upon the severity of the compliance. But it gives the building official some discretion to give some additional time. Additional inspections under both scenarios are authorized as necessary for enforcement of the ordinance, so nothing changes there. Inspection notice, in emergency situations, the city can come in and inspect at any given time, but must provide at any reasonable time, I should say, so nothing changes there. Inspection notice for non-emergency situations, the city will notify the owner and the owner and manager is then obligated to provide a notice to the tenant at least 24 hours in advance, and nothing changes in that regard either. One of the questions we get, though, is what if the inspection is refused? And currently, the city remedy for a refusal to allow the city in is the city would have to go get an administrative warrant if it's refused by the owner or tenant, or the city could revoke the registration. And again, under the proposed ordinance, if the inspection is refused, the city would still have the opportunity to get an administrative warrant. Let's say your tenant says, nope, you can't come in. As long as the landlord is cooperating, the city would then get an administrative warrant from the court to go in there so that there aren't any rights that are violated. And the city could then do its inspection. That's one of the concerns a lot of landlords have indicated is, I'm willing to comply, but what if my tenant doesn't? And as long as you're making the effort and participating and cooperating, it's not going to come back to bite you. I mean, it's the city will take it from there by getting a administrative warrant. And I have Joe Ellig, my assistant city attorney, who will speak a little bit on the constitutionality of that aspect, because I know that that's one of the issues that presents itself. One of the things that we've included that wasn't included in the current ordinance was what's called a provisional license. And that's where the city can issue a temporary provisional license when corrections are required, but do not constitute a fire, safety, or health hazard. And basically, if there's some of the corrections are unfeasible to correct because of lack of workers or contractors or materials or climatic, such as we can't make repairs in the winter for this type of thing, the city can issue a provisional license, which is a temporary license to buy that kind of time. And the provisional license is temporary and conditioned on the owner making the needed corrections with timelines determined by the building official, depending upon what needs to be done. So, I mean, we didn't have a provisional registration. We have a provisional license now, which will allow it to continue, but with an idea and a thought towards that the repairs would be made. Annual registration fee and inspections, again, the current practice is the best practices versus the standard practice, which either if you submitted yourself to inspections, you got a reduced rate, and if you didn't want to otherwise you'd pay the full fee as set forth, and you wouldn't be subjected to routine inspections. The difference, I think, is that the annual inspection fee is going to be set by the council, and it will include an inspection. There won't be a reduction given on the inspection fee. So, I mean, it's envisioned that everyone will be paying the same fee, but everyone will also be receiving the same inspections, and will have to bring units into compliance if the building official notes any discrepancies. Hazardous building unfit for human habitation. In either case, the city administrator retains the right to close buildings down that are hazards and create unfit living conditions for tenants. So nothing really changes in that regard either. Registration, denial, revocation, or suspension, nothing really changes in that aspect other than the fact that we are looking at incorporating another level of appeal if landlords or owners disagree with the decision. So the initial decision would be made by the city administrator, and then a licensee could appeal that decision to an independent hearing officer, and that person would then make a decision. And that's kind of that's the difference between the old or the current ordinance versus with a proposed ordinance, is to allow a hearing officer, independent hearing officer, to review the matter. And if they issue their decision and either the city or the licensee doesn't agree with that decision, then either party then may make their appeal to the city council and have the city council issue a final decision, which that's the same whether it's the current ordinance or the proposed ordinance. And then if a licensee disagrees with the city council's decision, they always retain the right to go to the Minnesota Court of Appeals to have them address the question. So, I mean, there really isn't any change in that regard. Penalties, there's a little bit of a change there, and let me explain how the change may impact you. For any penalty, it could result in a revocation or a suspension or denial of a license. I mean, any type of penalty could result in that. Currently, any type of penalty is typically prosecuted. It's charged as a criminal matter, and it goes to court. And so you get a ticket from law enforcement or the building official, and then you go and talk to the judge about it, and then you get to meet our fine prosecutor. However, in the current or in the proposed ordinance, we are also saying that that's an option to go to court, but there's another option too to stay out of court, and it's through an issuance of a civil fine that's set in the ordinance, as opposed to going to court. In criminal court, it's simply handled internally administratively. If there's a violation that normally would have gone to court, the option is to go, instead of going to court on a criminal court basis, is to go to and handle it administratively through a penalty. I don't know if anyone in here has had an administrative or a court fine or anything like that. It doesn't happen all that often. It typically, if it happens in some of the more difficult situations where someone isn't probably not bringing their building into compliance when they need to. So, I mean, we don't envision anything really changing in that regard. We're not going to be issuing more citations or anything like that. We're simply looking that there's two avenues instead of one. One avenue being the criminal, the other being an administrative, just handling it administratively. Oh.
Thanks, Chief.
Oh, thank you, Chief. Okay, sending out citations or something. Jeez. Yeah. Not here, Chief, not to the.
Sting.
All right. Reinstatement is always allowed, permitted, if the violations are corrected. Again, nothing changes in that regard. Disorderly conduct and crimes on the registered premises. Now, we all have a common interest that we want order. We don't want disorder on in any of our dwellings. And so there really isn't any change. The change simply makes it pretty clear as to what violations are the type that we're worried about. Drug violations are one. Other types of violations are, assaults and disorderly conducts and that type of stuff. Under the current ordinance, 3 violations within 90 days meant automatic revocation. So 3 and 90 meant revocation. Under the proposed 3 violations within 1 year, the city will request that you take action. An action could be to evict the tenant or to give them a 30-day notice to vacate the premises. If the owner fails to take an action to remove the tenant within 14 days of getting a notice from the city administrator could revoke the license then. I mean, if a tenant has 3 violations in a year, and you receive a notification from the city to say, deal with it, and you do nothing, the city administrator will revoke the license. If you take steps to remove the tenant, such as start an eviction proceeding or send them a 30-day notice, then you're not going to lose your rental registration as long as you're taking efforts to have that tenant removed. So as long as you're taking appropriate measures by either eviction process or providing a 30-day notice to tenant to vacate the premises, I mean, your license is fine. If the license holder has done either of these, the city administrator may not. So the city administrator is directed that he may not take adverse license action if you're undertaking those steps. Eviction proceeding, however, is not a bar to license action. I mean, so basically, just because you're doing it doesn't necessarily mean that if you say, well, see here, I got my eviction process going, it'll hold off on stuff for a while. But I mean, you do have to actively and diligently pursue the eviction process. You can't show up in court and say, I changed my mind, Judge, and have it dismissed. Not that you would, but I mean, it just makes it clear that as long as you're diligently pursuing eviction, that the city administrator will, work with you in maintaining the license. So that's kind of the meat and potatoes relating to some of the differences and comparisons of the the current ordinance and the proposed ordinance. The proposed ordinance also has some additional requirements, and you'll see them on the screen. And it's requiring the license holder to sign a document with the city that basically indicates you acknowledge the rental ordinance, the required rental property inspection conducted by the city inspector, and continued maintenance of the property. And it also indicates that there'll be some screening done of your tenants. Basically, through use of a rental application which contains some information to conduct criminal background checks and a credit history. I don't know how many of you are actually doing that. We do certainly encourage you to do that, as that's one of the things that empowers landlords. The more you know about your tenant, the better off you will always be. So one of the things that we encourage landlords is to do these checks. We do also indicate that all leases should be in writing. That's good practice too. I don't know of many landlords that do not have a written lease. It makes sense to have a written lease. The other thing that we also require is that part of the lease, you should have this crime-free, drug-free housing addendum. And I don't know how many of you currently have that as part of your lease, but what that does is it empowers landlords to say, if you commit crime in the dwelling, or you have drug activity in the dwelling, or someone you invite to the dwelling has any of that, it gives you an out of your lease. And it basically says is that it's a reason to terminate the lease. And we've seen it where the court will uphold those provisions. When you go to court for eviction process, you may have a year lease, but if you have something like this incorporated into the lease, it gives you an out. And it says that any violation is grounds for the landlord to evict or basically to terminate the lease. And that's a sample form is included on the ordinance. So I mean, I know there's a fair amount of landlords out there that have this already. And that's something that we encourage. Finally, we under Minnesota law, it's under the Kerry Koskin Manager Background Check Act. Many of you know that if you have a manager, you have to have that manager checked and a background study checked on that manager. State law requires it. And I've identified and I've provided the statute as to what identifies and defines what a manager is. And a manager is an individual who is hired or is applying to be hired by an owner, or who has or would have the means within the scope of the individual's duties to enter tenants' dwelling units. Manager does not include a person who is hired on a casual basis and not in the ongoing course of the business of the owner. So, I mean, when we think of manager, we think of a larger kind of entity that hires a manager to kind of take care of the premises, take care of the property, make minimal required certain types of repairs. So that's required by state law, that background checks of managers be conducted, and we can certainly imagine the horrific situation that required this law to be written. So that is kind of the comparison between the current ordinance with the proposed ordinance. My partner, Joe Ellig, is here to talk a little bit about the constitutionality of some of the provisions here. I'm sure he'll be pretty brief, but other than that, then we want to just kind of open it up for your comments to the council.
Thank you, Rolf. Yeah, Joe, do you want to just step up to the
Sure.
lectern if you would?
You want me to begin?
Yeah, go ahead.
Okay, yeah. Anyways, I've had the pleasure of dealing with challenges to our ordinance and regarding rental inspections. And so I've had to deal with that, and in reviewing the proposed ordinance and the changes and the ordinances that have been challenged, I can say that the requirement to provide, require that the units be inspected is constitutional. That particular issue has been addressed in state Supreme Court, and to have it in our ordinance to require that all units be inspected is constitutional, and in the event that, and Rolf alluded to this earlier, that in the event that the landlord or tenant does not allow inspection, then one of the recourses for the city is to get an administrative search warrant. And one of the things that was decided in our most recent state Supreme Court holding was that we didn't need, through getting application to the administrative search warrant, which is basically an application through district court, saying that we need to go in there to inspect it for housing codes and basic safety standards. That's all we need. What was argued in the state Supreme Court had to do with the appellants were arguing that we had to argue, we have to prove that there was some type of code violation. We don't have to prove that. We just have to say we're going to try to make sure that this unit is safe. And that's all we need to tell the district court. A little bit more complicated than that. But that's the recourse for the city in case that inspection is not allowed.
Thanks, Joe. All right, just before we get to the public comments, just real quickly, Lynn, were you going to put the proposed timeline on the screen? So if the ordinance moves forward, and again, the council will discuss this at its August 5th meeting, which would be a first reading if the council decides to go forward with this, but that's the proposed timeline. The second reading would be August 19th. Publication would be on the 22nd, effective date September 6th, letters sent October 15th, and the registration's due November 30th, which is in line with our current registration process. So with that, I want to welcome everyone the opportunity to address the council, give your thoughts, your concerns on this, and just please step to the lectern, state your name, your address. Again, we're going to keep it civil and respectful. That's understood. And again, I want everyone the opportunity to speak. If you are going to be repetitive, that's fine. We want everyone the opportunity, but just let's keep it relatively brief so we can move along. But again, everyone's welcome. So please, who wants to get us started? Good evening.
Good evening. I'm Sharon Taylor. What else did you need to know?
Address, please.
1002 North Broadway, Fergus Falls.
Good evening, Sharon.
Good evening. About the violations, will we be noticed or notified after the first violation, or do we have to wait for 3 violations before the landlord's even notified?
You'll be notified of the first violation.
Good, thank you.
Yep.
Thank you. That was an easy one. Check that one off. Who's next? Bob? You up next?
Me?
Yeah.
I haven't got it together yet.
All right,
I don't know if
all
I have
right.
a question or not right now.
All right, sounds good. Good evening.
Good evening. Bert Clark, 1303 South Sherman. For the first part of Part A of Section number 13 on the property, if somebody's brings stolen stuff onto the property, yes, I would think I would have to I would have to evict them. But if they're taking it, stealing and go bring it somewhere else, you're saying the landlord's responsible to kick them out?
What section are you referring to, sir?
It'd be section number 13 on the,
14.35.
for the legal issues. 4.35-11. It says any of the following parts 1 or part 2 of crimes.
See where he's looking?
It's number 13.
Number, after the first violation, this one here, 13, any of the following part 1 or 2 crimes.
Well,
Yeah, I can understand if somebody brings some stolen stuff onto my property, yes, they're gonna be gone immediately. But if they steal it and take it over to their friend's place, am I gonna evict them? Or is that gonna be a legal issue that the courts need to deal with?
that certainly could be a legal issue.
That's why that one I have a question with. The next part on part B, if somebody gets a DUI and their diagnosis is chemically dependent, who's going to accept responsibility if they say, wait a minute, that's part of my illness? And yes, I screwed up. But is the court, is the city council going to accept responsibility for all that? If they go take legal action saying you just violated my rights as a vulnerable adult?
I don't see a DWI triggering anything.
You said, they say 3 times and you have to evict them.
Well, 3 times of the
3
various-
DUIs, I've seen 3 DUIs in a,
No, but it's 3 violations of this ordinance. DWI does not necessarily violate this ordinance. A disorderly tenant would.
I'm getting to that.
Okay.
The next part is the disorderly tenant. If you have somebody who's has some psychosis, they can be screaming, they can be doing whatever. It's not against the law to be mentally ill. It's against the law. You can haul them in for being, if they're a danger to themselves or others. But they can be screaming at the top of the world. That's not against the law. Is it disorderly conduct? Yes. And there again, if they want to say afterwards, you can't do that because it's against my rights as a mentally ill person, who's going to accept responsibility for that?
Well, one of the
I don't want to be the one held accountable saying, wait a minute, you evicted me because I'm mentally ill?
Well, I think one of the things you could do is, you evicted me because I'm mentally ill, is you're bringing an eviction process based upon conduct that that person did. You don't evict them, a judge does. And I think if you engage an eviction process to remove a tenant that is a disorderly tenant, and whether they have a mental illness or not, they
Can you talk more into the mic, please?
Sure. And one of the things is that I think you always have the remedy and to go before the court and bring these types of violations to the judge.
She still can't.
Oh, okay. This doesn't preclude you from doing that. And if you're concerned about, about evicting a tenant that has disabilities, you go to the court, and if the court authorizes it, I think that eliminates any potential issue relating to evicting a tenant with disabilities.
So you want me to pay $300 and some to go to court on something I know they're not going to get evicted on?
How do you know?
Because I've worked in psych long enough and mental
Okay.
health long
No.
enough that
Well, I mean, and that's part of the problem with some of our mental health issues that we have that present themselves. I mean, the people are being mainstreamed and whatnot, and these are issues. I get it. I mean, and I think there are certain crimes out there that I think we all agree that if they occur on the premises, that they should result in a tenant being evicted. I think we all agree on probably 98% of it.
I've done that before, but
Yeah.
it's, next thing I have is, you're saying that the landlords, won't be able to just pay the extra fee and not have to have an
Inspection.
inspection?
Everyone, yep, the proposed ordinance, everyone pays the same license fee, and that includes a mandatory inspection once every 3 years.
Because my personal thing is, I wouldn't want somebody coming in my house and walking around my house. I'd actually probably become violent if somebody walked into my house saying they're going to inspect my house.
Yep, this
And
is,
that's just me, okay?
Yep.
And so would I expect that less of anybody else? Probably not. There again, that's one of the things I have. And the other thing I have is there's a property inspector that's here in town. I won't say the name, but I will not allow that person on my property. I do not want them anywhere near my property. I've been harassed by him enough that I don't want them there. What are you going to do about that? Anything? I can talk to you individually later if you
sure.
need. But,
Why don't we talk individually about that?
Okay.
I'd be happy to do so.
and then I'll also want a copy of this meeting because I want to make sure minutes of the meeting sent to my house, please.
There's a copy of the meeting will be available on the website.
I can't go on the website. I don't know how to do it.
We'll have to make sure the copy's available at City Hall in writing, or in paper form.
All right, thank you.
Thank you. Anyone else have any comments? Yes.
I guess I'd just like to
If you wouldn't mind, just please come up to the lectern, please.
My name's Linda Mertz, 20513 Hillcrest Road. And this whole thing, I feel, is railroaded. I'm not happy about it. We have nice property, but still, I don't think this is right. I don't like what the government is doing. I think it's insulting. I'm just very, very disappointed in all of you. And I think it's scary what the government of the city is trying to do.
Thank you very much.
You're welcome.
Any other comments? Questions? Steve?
Mr. Mayor, City Council. Stephen Benjamin, 510 South Court. I have some rentals in the city of Fergus Falls. Because it's in my best interest to keep the property fit for renters, it's not the city's responsibility to tell me how I have to keep it fit. I try to keep it safe so renters will stay and be happy. The only way I can't attract them if it's not fit for human habitation. I don't know why I'm put under this penalty, and I see it as a penalty. If you're hitting me over the head with a big something or other, it's not a carrot. They can at the present time, the renter has the power. They can complain to me if something's not right. If that doesn't work, they can request the city inspector to come. They can take legal action against me and not pay rent until I get things fixed. That's in state law already. They already have that that possibility. I wish it were that easy for me when I come across a renter that isn't doing things right. But getting to a specific question, is 4.35.2, would that be considered the grandfathering clause? And you talk about a built-in deficiency. Who is it that determines what that deficient, if it is a built-in deficiency or not? It said in this that it may be considered a built-in deficiency. Is that the individual inspector at that individual time? And if so, does a subsequent inspector, is that able to determine differently on that particular issue?
Ralph, is that something you want to comment now, or do you want to bring that?
Well, I think deficiencies are noted, any noted deficiency is going to be by the building official. We have two, I believe.
Okay, but say the next inspector, would they be able to say, okay, this is not a built-in deficiency, this isn't acceptable then?
I don't have an answer to that.
So it's basically subjective.
I think it's subjective only to the extent that you got a building inspector that looks at the laws in one instance, and I don't think necessarily the laws change.
No, the law, well, it said that it may be considered. It doesn't say that it will be considered. If it said it will be considered a built-in deficiency, then that would be fine. But if it's up to the building inspector, then building inspectors can change. You go through different building inspectors.
I understand that.
It looks like acceptable to one may not be acceptable to another.
Yeah, it's a building official question. It's... Yeah,
Okay, so basically it may or may not be. Okay. I'll let somebody else speak for a while. Thank you.
Thank you. Steve? Anyone else like to speak? Make comments, ask questions? Going once? Sharon, did you have another comment?
Well, I've said this so many times before. It seems like this kind of comes in waves at us, and this is, I think, the third time that I've said my renters, some of them are pillars of the community who have decided to sell their home and live in a rental. If they were in their home, you would not come into their place and inspect their home. And I don't want my renters to have to be subjected to that either.
Thank you.
We too we have 3 rental units, and we too have worked hard to make sure that they're
Pam,
in.
just state your name. Yeah,
Pam
sorry, not to
Janish.
interrupt you. Yeah.
Pam Janish, 124 South Lakeside Drive. My husband is Gary. We've worked hard to try and keep our properties in good shape. We have chosen to pay the extra fee on 2 of our units because the renters get extremely upset about the idea that someone would come in and inspect their property. They're not lawbreakers, they're just very private people. And so out of respect for them, we have agreed that we would not do that with the city. Interestingly enough, one of them has an annual inspection with HRA, and they have no problem with HRA inspecting, but they're very opposed to the idea of the city building inspector coming in. I think it's partially because they've developed a relationship with that HRA person through the whole process of applying, et cetera. The other one, I'll be the first to admit, she's a little bit of a hoarder. We tend to go in ourselves and say, okay, what can we do to help you, kind of get things going? But the reason that we choose to do standard is out of respect for our renters. I'm with a few of the other people that way. The other is that I guess I too have a little bit of issue with, and I know where it comes from, but I do have a little bit of an issue being told that this is exactly what you will do. this is how it will happen, primarily because the people that come into mine they're in an older home. And so my rent isn't as high as the $800 and $1,200 places around town that are in the bigger buildings. And, we work hard to keep those prices lower. And every time the government steps in, whether it's city, state, whatever, those prices raise. I don't have any choice but to pass that on to them if we're paying the additional inspection fees, whatever. And I guess I just have, although I know why it happens, we have a property actually 2 doors away from us that was closed. It has a hazard sign on it. It was a rental property. I understand why, but I also think that you need to take into consideration that the people that are renting from us also have some responsibility and some rights to make sure that they're going into a safe place. And I think that we're taking away some of their choices.
Sure. Thank you, Pam.
Ben, did you want me to talk a little bit more about the constitutional? It sounds like that's what we're talking about now, or not. It's up to you.
I mean, Supreme Court made a ruling, right?
It's fine.
I mean, maybe if there's questions if the council has questions on Monday night, if Ralph can address it, I think what you said was pretty much the end. Anyone else like to? Yes,
I would,
Linda, if you wouldn't mind, just come up to the lectern.
I would just like to know, when you were considering all this, what were you taking in mind about the rights of the tenants? Did it even occur to you? Do I get an answer?
Yeah, so the council's we're just looking for feedback tonight. We obviously
Well,
understand
how did you come up with some of this? You come up with a lot of stuff. Didn't you think of the tenants' rights?
So we just, again, the council's going to discuss on Monday night, and the public is obviously welcome,
Okay,
but,
think about it.
sure, I just would say that,
They pay taxes in the city also.
Yep, certainly.
You didn't answer that.
So the current, the way I understand, the current proposed ordinance is modeled on an ordinance from Golden Valley, I believe, the one that Joe referenced in his comments earlier. Is that?
There's a number of the key provisions are very consistent with Golden Valley, and some of the language is pulled from Golden Valley. This is also modeled after what they do in Burnsville, Apple Valley, were looked at as well.
We're not a metropolitan
I-
area.
And then I would just, the only thing, again, we're not going to have back and forth tonight. We'll have our discussion Monday night, which the public is more than happy to. And one of the things that I think that I will ask staff is since 2000 and I'm going to be 14. When was it initiated? 2014?
14 or 15.
And it went into effect 15. So right now, currently, I have 1,166 units that are inspected. So it's not like this is a brand new thing for us to inspect the units. So that's something that we will discuss on Monday night as well. Any other comments to the council? Yes, Bob.
Well, I thought about 20 questions, but I'll
Pardon?
keep it short. I've thought about 20
Sure.
questions, but
Sure.
Bob Noah, 1004 North Broadway, Fergus. Have any of the tenants in the city, has there been a survey of any of the tenants to find out what we think about these ordinances? Because we're going to ultimately pay the cost of any licensing. And the other question is, how much is this licensing? And how much to hire somebody to oversee this whole project? There's 3 questions for you, but the most is, what about us renters that are really happy with our places, and our rents are going to go up because of it, somewhat. And what we think is important. So you can impose what you want and do what you want, but if you haven't talked to us, the people that are most impacted by this, then have you really done your homework? That's all I got.
Thanks, Bob.
Can I ask a question? What's a violation? What does this tenant have to do in order to be evicted, besides drugs?
Sure. So that's Edie Benjamin has a question, just for the record, just to make sure it's on the record. So Edie's asking did you catch that question?
Yeah, I mean, if you take a look at 4.3511, it lists a number of offenses. Do you have that in front? I mean, you've been provided that, and you look at the subsection A, and it lists 18 offenses. Okay?
Any other questions or comments? Yes, Sue.
Hi, I'm Sue Tisdall at 28201 North Midway Park Drive in Battle Lake. And we have property here in Fergus and have for several years. I just have a couple questions. I don't know if they're good, bad, whatever, indifferent. But under the 4.35.6 for inspections, it has in here that every 3 years that they're going to be inspected. And then if there's a shared common area, that an annual fire inspection is going to be completed. How does that work? Do you guys just let us know, like, we're going to, like, or is it something we need to contact the city and say, okay, we're ready for our fire inspection? Or do we contact the fire or how does that work?
The fire department's required to inspect common areas annually, and I believe, I don't know if we have a representative, is the chief here?
Dean's back here.
Oh, yeah, and I believe they do actually do those inspections annually. I believe they would contact the owner to arrange for that inspection of the common area.
Okay, perfect. And then, is there going to be a registration fee and a license fee, or is it just all going to a license fee?
License fee.
Okay, and do we know about what that is?
We don't.
Okay, that's all I had. Thank you.
All right, any other last closing questions, comments? All right, thank you everyone for being here tonight. Again, this will be discussed at the council level, whether or not they want to move forward with this ordinance a week from tonight, Monday, August 5th, and that meeting's open to the public. So, thanks everyone.
Thank you, Mayor.